they're both getting it. It's the first ever award, yeah. And
Yeah. I've heard that a lot of times. Please rise. Justice of the Appellate Division, Supreme Court, First Department. Hear, all persons having business with the Appellate Division are here. Give your attendance and you shall be heard. Please be seated.
Good afternoon. Welcome to the Appellate Division First Department. This afternoon, not bad, we have about 5 hours of argument time that's been requested. So please bear that in mind as I call the calendar so that you can ask only for the time you need to make your most important arguments. Understand that we have your briefs, we have the records, and we are fully familiar with the facts of the case. So starting with People versus Laru Curls. 6, 2, and 6. Rich versus J.A. Madison. I'll give you 6, 2, and 6. Thank you. Rose H. versus Michael H. is submitted. Rooney versus the City of New York. 6, 2, and 6. Thank you. People versus Richie Rivera. Give you 5, 2, and 5. Assad Technology versus CNY Construction. I'll give you 7 and 1 and 7. People versus Jesse Noel, or I'm sorry, Noel? Both. Yes. Okay. I'll give you 5 and 2 and 3. Saunders versus Fauci. 5 and 2 and 5. Mason versus NYU. 5, 2, and 5. Vanguard Construction versus 400 Times Square. 5, 2, and 4. People versus Zeliang Pan. 6, 2, and 6. Perot versus Bloomberg is submitted. Khan versus Garg is submitted. Remember that when the red light goes on, you have to stop, but we will continue to ask you questions if we need to. So. People versus Curls. Just a minute, please. Okay.
Good afternoon, Your Honors. Mr. Curls did not intelligently, knowingly, and voluntarily waive his right to counsel when he was told he faced a minimum of 5 years immediately before he effectuated that waiver.
Why wasn't it a searching inquiry pursuant to Blue, where the judge asked very detailed questions and neither Blue nor the Supreme Court requires a specific recitation. There's no rigid formula that's required. There are no specific requirements for the minimum range or the minimum amount. Here, I understand that the judge got it wrong, but the prosecutor got it right and gave that the correct minimum when it was requested.
Well,
So why
certainly,
wasn't that searching under Blue?
I will agree that the inquiry was certainly long. There were lots of questions asked on a variety of topics, but the touchstone is intelligent, knowing, and voluntary. And so here, the Court of Appeals says that it's a question of whether the defendant went into the decision with eyes open. And the range of allowable punishments is part of that. It's still part of the CJA model colloquy. I understand that the court can say, Mr. Defendant, you're facing a very, very long period of time, and that would be sufficient under Blue. But here we have Mr. Curls, who had 3.5 years already in at the time that he's told that he's facing a minimum of 5. The fact that the prosecutor tried to correct the court and said, well, it's 8, tells me that maybe the prosecutor knew, but does not tell me that Mr. Curls knew.
Well, didn't the defendant in the prior 440 indicate or include what the minimum was? How does that affect the analysis?
Well, so several months before then, in page 2 of a legal memorandum, defense counsel did mention that the minimum was 8 years. At the point of the colloquy, the court is telling him 5, and the fact that the court is correcting the prosecution's statement of 8 would, for any person who's not a lawyer, and even a person who is a lawyer, apparently the judge, the belief that at the time of the waiver would be 5 years.
So you're saying I can't recall if the prosecutor had the last word or if the judge corrected the prosecutor after he indicated the 8.
So the court says, can you please state, I'm sure if he would be convicted of attempted murder as a hate crime, what would the sentencing range be? And the prosecutor says 8 to 25. The court says, I believe.
And that's correct, the 8 to 25.
That is absolutely correct. The court says, I believe the correct range is 5 to 25. I just want to confirm that. I believe the first range for the first B violent is 5 years determinate to 25 years determinate with supervised release to follow. And so any person who's hearing that would hear the prosecutor says 8. The court has now said 5 and said, let me double check. Yes, 5. And so.
And let me ask you another question then. I get your point on that. What about with regard to just whether or not he was capable of giving a knowing waiver with regard to his mental health? He answers a number of questions. I'm wondering, is it enough simply to ask the questions, or must the answers also be reviewed? And here he's asked, that he has a lot of experience in the criminal world. At an earlier time, he said it was in California and, let's say, Kansas, or I think it was Kansas. This time, he says California and Minnesota. Is there an obligation to double check to see whether that's actually true? He's asked whether he's had any psychiatric history or any psychiatric treatment. He was treated in 2016 at Bellevue. He says no. Does any of that go to whether or not he is stable, has a stable mental health capacity in order to proceed in a knowing and intelligent way?
Yes, it does. I think that the Court of Appeals in Blue specifically references a prior case where it says that when there isn't a range given to the defendant, but there are other factors, the waiver may be not intelligent, knowing, and voluntary. And here we have somebody who has, the court has a 730 report before it, and my client referenced a 730 report that clearly stated that he had been hospitalized, he had been medicated before, and he's telling the court that I've never been treated for any mental health condition. Every single answer he's given about his mental health is contradicted by the 730 reports. And I think that goes, it's difficult. Obviously, I'm not expecting the court to order court files from Kansas to double check what's being said in a colloquy, But in this case, you have somebody who, with red flags that are before the court, and who is also misinformed of the range. And I think that combination puts it squarely as an ineffective waiver.
What about the fact that the attorney, the third or fourth, I think it's the third attorney, actually is in the trial and does do the voir dire, and or at least asks questions during the voir dire, as well as asks questions of the witness, so or witnesses. So he does take an active role. Does that overcome any issue that may have arisen in this searching inquiry?
No, I don't believe so. And indeed, my client conducted the opening and closing statements. He forewent the first round of voir dire entirely, and obviously this court knows voir dire is very important. He conducted much of the examination, but this is not part of the inquiry. There's no prejudice. He took that right to go pro se, that he, after having waived counsel, and used it to, honestly, to his detriment. But even if he were better than he was and presented a valid, cognizable defense, the question would still be, was it an intelligent, knowing, and voluntary waiver? And that helps cabin this court's inquiry as to where to look for evidence of that.
Thank you.
May it please the court, Alex King for the people. Defendant validly waived his right to counsel.
So it seems to me that your adversary is arguing that at a point that you concede, which is that the judge below got the stated minimum wrong.
No.
Is that enough? Is that enough to invalidate this whole thing?
First, Your Honor, we do not concede that the judge got the stated minimum wrong.
Well, he said 5. It's not 5, is it?
So in context, the judge seems to have been describing the minimum sentence.
Right, without the hate crime, the straight assault.
Correct.
But he's charged with a hate crime.
He was charged with a hate crime, but the judge said this was the first range for the first B violent felony, which was absolutely correct. At any rate, no matter what the judge said or what defendant understood the judge to mean, defendant received correct countervailing information in real time from the prosecutor, who said accurately the range.
I think it's reasonable to conclude or to think that when the judge is saying a number and the prosecutor is saying a number, you're the defendant, that you're probably going to believe the judge, right? So assuming that that's the case, is that enough to invalidate what happened, the rest of it?
It certainly is not. We know that from the Court of Appeals decision last year in People versus Blue. Even if there had been an error as to this single issue, the lesson of Blue is that no one factor is dispositive. Here, on the whole, the colloquy was extremely thorough.
So I'll ask you this. Is it enough that the questions that are asked are searching, or does one also have to look at the answers that are given to make a determination as to whether the defendant is knowingly and intelligently waiving?
The questions are the most important, but certainly both are relevant. In this case, Justice Klott had all of the information that he needed.
So the questions are more important than the answers the defendant gives to determine whether the defendant is knowingly and intelligently waiving something.
Both are important, Your Honor. It's important to look at the context of this case. The record plainly demonstrates that whenever it was convenient for a defendant to claim that he had mental illness, that is what he did. And whenever it was convenient for a defendant to claim the opposite, he claimed the
So you're
opposite.
talking about goal-oriented and manipulative. Who's making that determination? That sounds like some sort of psychiatric determination. I don't think anybody in the court was such. So who's making that determination of goal-oriented and manipulative versus some psychiatric impediment?
This was a legal determination for the judge to make. Justice Klott, at this point in the proceedings, was extraordinarily familiar with defendant and his antics. The judge did not need to ask defendant whether he had been lying before or was lying now. It's helpful to compare this case with this court's
So you're
decision.
saying that the judge knew that he had psychiatric issues and had been hospitalized for psychiatric issues when he asked him whether he had been hospitalized before?
Precisely. The judge made very clear on the record that he had read the 730 reports, which again determined that defendant was fit to stand trial.
Fit to stand trial, but I'm talking about the 2016 prior The prior hospitalization is what I'm referring to.
Yes, and the judge was aware of the prior hospitalization because Justice Klott was very familiar with this case. Again, making this case very much unlike People versus Z, which is what defendant relies upon. In that case, the judge was presiding over that matter for the first time, was not aware apparently that there had even been a 7:30 examination.
Is the defendant's prior hospitalization either an automatic or per se bar to him representing himself?
Of course not. Of course not, Your Honor.
But it may not be a bar, but the question is whether or not he has, the mental capacity to represent himself. I mean, one may be competent to stand trial, but not competent to waive the right to represent oneself by counsel. There's a difference.
This court has said otherwise, but even assuming that that is correct, defendant was
And not be competent, therefore, to understand the waiver.
Defendant in this case was surely competent to do both. And the fact that he gave some conflicting answers was evidence of his competence, because when it was convenient for him to claim that he had mental illness because he did not want to stand
Are you talking about within that period before Judge Klott, or are you talking about previous occasions?
I'm talking about the entire record in this case. Judge Klott was aware
Well,
of what had
Judge
happened
Klott
before.
was doing that one inquiry. We're talking about Judge Klott's one inquiry on that day. We're talking about that as a searching inquiry, not everything that transpired before.
We're talking about both, Your Honor. Both, what happened in this case, both Justice Klott did a searching inquiry on that day, taking up, I think, more than 20 pages of transcript and closely tracking almost verbatim the model colloquy. But this was, I believe, Justice Klott's fourth time proceeding over this case. He was very familiar with defendant, and defendant had been warned about the risks of proceeding pro se by judges in the past over the course of many, many years.
Judge Burke also warned him, correct?
Yes.
And Judge Clout also created hypothetical questions regarding what would happen at trial and sentencing, correct?
Yes.
Painted a word picture of what the disadvantages would be at going for pro se, correct?
He did. He did exactly what a judge is supposed to do in this situation. If there are no further questions, we ask that you affirm.
The people say that Judge Klott was very familiar with my client, and with that familiarity, he chose to begin the colloquy with the range of punishments my client may face after trial. I would argue that People v. Blue stands for the proposition that when the court exaggerates the risk or says something is very...
Let me ask you straight, because I asked it of your opponent, but I'll give you an opportunity. Is it your position that Judge Klott's error in that stated minimum, that in and of itself tanks the whole colloquy?
Yes, in this case, when he had 3.5 years in.
How does that jive with Blue, where it says that a reviewing court may look at the whole record, not simply to the questions asked and answers given during a waiver colloquy to determine whether the defendant effectively waived counsel?
Because if immediately after that or during the course of the next date, if my client had said, I know I'm looking at 8, or if there was some other indication that at the time of that waiver he understood that the prosecutor had been right, then this court should look at that record for what he understood at the time of the waiver. And I think that's what People v. Blue stands for, and I think that's common sense. That is not the case here. And I think Blue stands for the proposition that when the defendant might believe that he's facing an enormous amount of time, then you don't need to give him the specific range. But here, the range the court gives him is lower than what the actual risk is, especially for somebody with 3.5 years in who knows that it takes a little bit time to get to trial. He's looking at a minimum that's in reach of his CR date. Now, I want to just address his mental health concerns. I will say that the Court of Appeals in People v. Stone has said that a question of a waiver's validity may well turn, even in major part, on the mental capability of the defendant, which also implies that even in minor part, it may turn on his capability. He was in Bellevue Hospital for 2 weeks before a 7:30 report was ordered. He'd been hospitalized prior to that. And so this is somebody who has some kind of mental health issue going on. He'd been prescribed antipsychotics. And so I think that at a minimum, it requires a little extra care, and a little extra care is inconsistent with telling the defendant the incorrect minimum range at the outset.
Counsel, I have one last question for you. I'm reading the transcript. The court says, I believe the correct range is 5 to 25 years. I just want to confirm that. And then goes on to say, I believe the first range for the first B violent is 5 years determinate to 25 years determinate. When does he confirm? He just continues to say, I believe, I want to confirm. When does he confirm based on what you said prior that he said it is?
I mean, my reading of this transcript is that he's saying, like, he says it's 5 to 25, he wants to confirm, and then his next sentence is, I believe it's 5 to 25. And while I, sitting here knowing he's wrong, can understand that he couched that in I believe, but that's the best evidence that the defendant in this case has of knowing what he is facing after trial when the court tells him he believes. The court believes the minimum is 5. And whose belief is more important to the defendant here, the court or the prosecutor? I would say the court.
Thank you.
Thank you. Thank you both. Rich versus J.A. Madison.
May it please
Just
the
a
court.
minute.
Sorry.
Okay.
May I proceed? May it please the court, my name is Stephen Kaplan from Kaplan Levinson, and I represent the appellant, Jonathan Adler Enterprises. Your Honors, this is an appeal taken from a decision after a trial to the court.
So since it's a non-jury trial, the judge had several witnesses over a course of a couple-day trial, and she was in a position to assess their credibility and listen to that testimony. So why, in the first instance, would we overturn her determinations here? What is it that you say that she did so wrong that we up here now should go the other way from the trial judge?
Okay, Your Honor, this appeal has nothing to do with any assessments of credibility. The first and significant error that we believe is reversible is that the trial decision opens up and says the sole issue to be decided is whether Jonathan Adler Enterprises, which is the parent entity, completely
Yeah, but then very shortly thereafter, the court says that, but the plaintiff must show domination was used to commit fraud or wrong. So it seems pretty obvious that the court understands that you need, in order for domination, you need some sort of fraud or wrong to be able to pierce the corporate veil.
Although I think, Your Honor, I'm looking at the decision, and of course I've read the decision extensively, and it does define the issue at trial as, did Jonathan Adler Enterprises dominate? And that there was no discussion throughout the decision of whether the second prong, the fraud prong, or the abuse of the forum, the corporate form, was satisfied. It was not discussed at all. There was one point in the decision, without any analysis, where the court went through and listed a bunch of the different reasons that the court believed the domination factor had been satisfied, and then just said, and then there was a wrong. And the only wrong that was identified both by the court identified one wrong, which was the dissolution of the subsidiary of Jonathan Adler, J.A. Madison, which I'll address in a moment. The plaintiffs argued nothing, but in submissions to the court, and to this court, argued two things.
But you're saying that the court below didn't just the sole issue, but it couldn't have been the sole issue if she did address a wrong.
But I would argue, Your Honor, that the court didn't address the wrong. The discussion of the entire decision and all the findings of fact relate only to the first prong, as the court said it was going to do. There was no evidence introduced at trial that could satisfy the abuse of the corporate form. And I say, just to sort of set the table and set the lens that we look through, the Court of Appeals and this court consistently has said that New York law disfavors disregarding the corporate form, and it's a very heavy burden for the plaintiff. It's not an ordinary burden, and it's not something that any court throws away lightly. When I say it, meaning the corporate form. Here, we don't believe that the first prong was satisfied, and I'll get to that. But more importantly, the second one was not addressed by the court to the extent that there was some what I would call dicta in there that where the only thing that the court said was that the payments weren't made under the contract. Breaching a contract is not the wrong. It's not the abuse of the corporate form.
In other words, there's nothing in the record that establishes fraud here.
Correct. I think there's nothing.
Well, can it be, does it have to rise to the level of fraud, or can it be some type of inequity that the court finds here?
You're correct, Your Honor. It's known as the fraud prong, and there is authority saying it doesn't have to rise to the level of an actual common law fraud.
Well, let me ask you about going back to the first prong, which we all agree on. So the contract, the so-called consulting contract, although I think nobody thinks there is really any consulting going on, but there was a consulting contract, right? And it was under that contract that the plaintiffs were to be getting the monthly payments of $8,000 plus a little bit more, right?
Correct. By
So
J.A. Madison.
that was, yes, with J.A. Madison. But didn't every check actually come from Jonathan Adler Enterprises?
Yes.
Did J.A. Madison even have a bank account?
Yes.
Where did it have, what evidence was there to show that?
There was testimony in the, there were no bank records. There was testimony, multiple times there was testimony that J.A. Madison did have a bank account. And I will,
Nobody ever brought in something and said, I mean, if somebody asked me if I had a bank account, I said, yeah, here's my check. See, I have a bank account.
agreed. It was never requested in discovery. It was never a document that was,
Was it ever challenged?
Burden.
Was it challenged?
No. And it wasn't challenged. What was elicited on cross-examination, I want to be very clear, is that each of the subsidiaries that operated a retail store did have a bank account. It was its account designated for it. The legal title of each of those accounts was in Enterprise's name, but there were local branches used by each store designated solely for the use of that store. So I just want to be clear, when I said that there were bank accounts, they were in the legal name under our loan facility of Jonathan Adler Enterprises, because
The lender required that.
the lender required that
Yeah, but I
contractually.
mean, but they did. It doesn't sound to me that they actually had a separate bank account. And it sounded to me like people would come into the store and pay with their credit cards, and then by the end of the day, sometimes in the middle of the day, that would be swept and taken into the account of Jonathan Adler Enterprises, the parent company, and that's who would pay all the bills.
Right. No, well, no, that's not who would pay all the bills. What you're correct. The first part of what you said is correct. The credit card processing was done through J.A. Madison, through J.A. Madison's account, unrefuted testimony. On a daily basis, the lender swept all the different subsidiaries' accounts in and through a lockbox and serviced the debt automatically. That's how these asset-based loans work with multiple subsidiaries. So you're correct. And then because they're centralized.
So you're saying it wasn't JAE that had any control over that once it was swept into this lockbox of the lender?
The lender controlled it. The lender had control under the loan facility. And I mean, I see my time is up, and if I can continue just.
Yes,
for a
as I
moment.
said, when the light, it's for you, not for us, if there are questions.
Thank you.
Go ahead.
So you're correct, and I would. This is what I would say. We're talking right now about the domination prong.
Right.
There's 9 factors. There were 4 invoked by the plaintiff. The first 2 are that there was that there was intermingling of funds, and there was that the subsidiary was undercapitalized, and they argued the same thing. So those are one and the same, and there was no evidence, and the plaintiff freely admitted at cross-examination he had absolutely no knowledge of the capitalization of either entity.
Yeah, well, why would the plaintiff have knowledge of the capitalization? I mean, when they entered into this consulting agreement, they were supposed to go and figure out what the capitalization of J.A. Madison was?
Yes. In other words, first
They
of all,
had an obligation to do that?
no, well, I'm going to say 2 things. One, it is the plaintiff's burden to pierce the corporate veil. So it's the plaintiff's burden to have requested and received in discovery that information. Secondly, at the time the consulting agreement was executed, Mr. Rich admitted freely he made no attempt to assess the creditworthiness of either entity. He made no attempt to ask for financial statements. He knew that Jonathan Adler Enterprises was a guarantor of the lease for the store next door. They were adjoining stores, and that he didn't ask for a guarantee. So there was everything that happened here was fully transparent. There has been a free admission by Mr. Rich on cross-examination that he knows of no conduct that either of the Adler entities engaged in that was deceptive, manipulative, wrongful. All he knows is that he didn't get paid. And that's not enough to pierce the corporate veil.
Thank you.
Thank you, Your Honors.
Good afternoon, Your Honors. May it please the court, my name is Elizabeth Sandercock, and I represent the plaintiff respondents George and Regina Rich in this action. There is no basis to the appellant's claim that the court did not properly consider both prongs of the alter ego test when entering judgment against Jonathan Adler Enterprises. A review of the record and the court's decision shows that those arguments are completely unsupported. And I would add that the brief is filled with misrepresentations regarding the testimony. Primarily, this claim that J.A. Madison and the other subsidiaries had their own bank accounts, when Carol DiCarlo, the controller for Jonathan Adler Enterprises, who also testified that she never worked for Jonathan J.A. Madison or any of the subsidiaries, testified at length about the way that the Jonathan Adler Enterprises account worked. It was one central account, and all of the proceeds from the various subsidiaries went into that account.
Now, was that because of the lender? Did
Yes.
it go into this lockbox and then get taken by the lender before being?
Well, according to Jonathan Adler Enterprises, that is the reason for the arrangement. However, that does not excuse the fact that they left each of their subsidiaries, including J.A. Madison, completely judgment-proof. There were no assets in J.A. Madison's name. The court even inquired about that.
I just want to be clear that that was something that was precipitated because of the lender.
That is the testimony. Your
And there's
Honor.
been, I mean, you or someone else would have had an opportunity to question about that, or to see documents about it, or to discover documents about it. Presumably that was done.
Yes.
And that's what you found, that it was the lender.
I don't believe any discovery was done, but the only testimony on that issue, Your Honor, but the only information I have is that, yes, that was due to the arrangements they had with their lender.
Were there any other officers of J.A. Madison other than?
Then David Frankel, Your Honor.
He was the president?
Yes,
He was the president of both.
He was the president of both, and there were no other officers that were identified. Mr. Carlo, who again was the controller for Jonathan Adler Enterprises and did not work for J.A. Madison, seems to have played a significant role in the organization of J.A. Madison's affairs. She received...
When the Riches were no longer getting paid or getting paid the full amount and then eventually getting paid it all by J.A. Madison, it was Ms. DiCarlo, the controller of Jonathan Adler Enterprises, that called up to try to negotiate something, right?
Yes, that's correct. She was responsible for issuing all payments. The Riches had received all of the previous payments under the agreement from her from the account for Jonathan Adler Enterprises, and she was attempting to negotiate with George and Regina Rich, and testified at trial that she was the one who ultimately made the decision to stop payments because no agreement could be, because she testified at trial that Mr. Rich, our client, said that he was going to speak to his attorney, and that, she said that ended the conversation.
It was a legitimate, wouldn't you say it's a legitimate business attempt to get a rent concession or to get a concession? I would like to not have to pay what I have to under the consulting agreement. That's fair. I need more time because business has been slow.
I think
That's not deceptive.
I think that it's reasonable to reach out and see if there's a way to reach a concession on a payment or an extended payment plan or something to that effect. However, I don't think it's reasonable to simply stop the payments altogether. And
That's a breach of contract. I'm not arguing that. But this whole concern here is whether JAE dominated, controlled, and perpetuated some type of fraud against your client. And what's clear on this record, at least from what I saw, is Mr. Rich did not claim any deception when he entered into the consulting agreement, correct?
No, there was no, I don't.
And there's no evidence of record that suggests that any of the subsidiaries, including J.A. Madison, was a sham of any kind, that they weren't legitimate businesses operating with their own phone numbers or their own personnel, their own addresses, et cetera, et cetera. None of that, just bear with me for a moment. Am I correct?
Your Honor, the plaintiffs have not alleged that they were misled when they entered into the consulting agreement. However, I will say that these subsidiaries were operated at, and I think the name of the theory here is appropriate, as an alter ego or as a department of Jonathan Adler Enterprises. The employees for the subsidiaries were store employees. It doesn't, based on the evidence at trial, they did not exercise any discretion in terms of business decisions. Mr. Carlo, who again only worked for Jonathan Adler Enterprises, was the one who was responsible for negotiating these agreements in terms of rent concessions and issuing payments under the leases and agreements that had been entered into.
It sounds like there are two things, that the president is the same for each, JAE and JA Madison, and that the controller is for JAE, but on this occasion, when they were seeming to have some financial issues, she reached out on behalf of the president of JAE to discuss the JA Madison consulting, payment of the consulting agreement.
Well, Your Honor, it goes beyond when there were financial.
Were there any other times when she reached out to, I mean, we're talking about once there was this issue with payment, she reached out for that issue. But then there were all the other things that my colleague has just mentioned. Why don't those things show, you know, a regular, non-fraudulent business?
Well, Your Honor, I believe that the first contact that the Riches had with Mr. Carlo was when there was a payment issue. However, from the evidence, from Mr. Carlo's testimony at trial, she was responsible for making payments under all of the agreements that were entered into by subsidiaries. She was responsible for, as we raised at trial, that the process of service address for both J.A. Madison and Jonathan Adler Enterprises was 333 Hudson Street. And when asked about that, Mr. Carlo said, well, she needed to see all the paperwork that came in so that she could send it over to the store employees and tell them what was important, because they weren't making those decisions.
Also, is a parent's decision to cause a subsidiary to stop paying rent, breach its lease, does that constitute a wrong that's sufficient to pierce the corporate veil?
Yes, Your Honor, and this court has found that on more than one occasion.
Hasn't this court also found the exact opposite, that a breach of contract is not enough?
Yes, under different circumstances, Your Honor. In a case that is, in a case where the facts are highly similar to the current case, BP 399 Park Avenue LLC versus Pret 399 Park, this court found that the parent company, the Pret parent company's decision to stop paying rent and to breach the lease constituted wrongdoing sufficient to pierce the corporate veil. This court also found in a similar case back in 1994, Simplicity Pattern versus Miami True Color Offset, that the decision to stop paying rent for the subsidiary and breaching the subsidiary's lease was sufficient to pierce the corporate veil. And in making that decision, the court looked to the inadequate capitalization of the subsidiary, the overlap in ownership, directors, and personnel, and the common addresses and phone numbers of the subsidiary and the parent company.
Didn't the subsidiary testify? I don't know if he put. I don't recall if he put in any proof that he had an office in the J.A. Madison store, which was next door.
There's the testimony at trial indicated that the manager of the store had an office at the location. However, it doesn't appear that the manager had any discretion over business beyond what occurred in the store itself. The business decisions were all made by Jonathan Adler Enterprises, Your Honor.
Thank you.
If there's nothing else, I'll rest. Thank you, Your Honor.
Your Honors, very briefly, Your Honor had pointed out that there were a few conflicting decisions about whether the breach of contract could satisfy the wrong, which was the only time the subject of the abuse of the corporate fraud prong was discussed by my colleague. The BP 399 case lies in very stark contrast to this case. In that case, that involved the franchise business. We've seen Pret a Manger all over New York City. In that case, the parent entity conceded that it alone managed the subsidiary. The subsidiary had no purpose other than the lease, and that in that case, what they did was...
Well, in this case, wasn't the subsidiary's only asset the lease?
No.
What else?
There was extensive testimony that the inventory belonged, and that's conceded by the plaintiff in their brief. The inventory belonged to J.A. Madison, that J.A. Madison's receivables came in, they were its, but then, yes, they were swept in and replaced the next day by new receivables. But the fact that those receivables might not be available for the plaintiff to garnish is not a wrong. Okay, it's the lending facility, and even without the sweeping, remember, all of the assets, receivables, bank accounts, inventory was all pledged to the lender. So every asset was pledged up anyway, which really goes to the other wrong, I think, that the plaintiff, not at trial, but now in the context of this appeal, argues was a wrong. The dissolution of the entity took place 10 months after the store closed. This was an LLC, not a corporation, so there's no notice requirements. And at that time, there was unrefuted testimony that there were no assets, no distributions, unlike, for example, in the Pret a Manger, the BP 399 case, where what they did was they closed down one location and literally took all of the refrigeration, the tables, the chairs, the counters, the kitchen, and moved it across the street and opened a new one under a different name. That's the prototypical wrong when you pierce the corporate veil. Not in this case, where you had a separately operating business with its own employees. And I beg to differ with my adversary on the discretion of the manager who ran every aspect of the store, hiring and firing, dealing with the landlord, setting up the store, inventorying the store, merchandising the store, running everything about the store.
The service of process address was the same for both, correct?
Right, but that was just...
But they did file separate biennial statements, correct?
Correct.
They didn't file together, correct?
That's correct. Each entity formed its own, and a service of process address is not the equivalent of sharing an office. It's undisputed that each store had its own office.
J.A. Madison had his own office and its own telephone number.
Yes, in addition to other things. Your Honor, thank you very much for your time.
Thank you both. Rooney versus the City of New York.
Good afternoon, Your Honors.
Good afternoon.
Okay. My name is Mike Daly, and I represent former police officer Terrence Rooney.
Well, as Warner Wolf used to always say, let's look at the tape.
Well, you got a lot of tapes to look at, Judge.
So the tape is pretty revealing, and for the deputy
There's three
commissioner of
separate
trials
offenses,
to
so
look
we're
at the
talking
tape.
about which videotape, the one
I
involving
think
the
23062, the one, I think it's 23062, the one with the wrongful arrest to begin.
Ms. Christie.
Okay, Ms. Christie, thank you.
I'm sorry, thank you.
Yeah, I for my own use, I call it the drugstore incident, the domestic violence incident, and the romantic gesture gone awry.
And in each one of these, the issue is substantial evidence, and that's a low bar.
It's a low bar.
It's lower than preponderance of the evidence, and I think that's where the issue is here.
Okay. But with all due respect, low bar does not mean free pass.
Not at all, but
There are
when,
certainly-
as my colleague was getting to, what do you do with the videos in the arrest with the name calling and the pushing and everything else that that does not, and then it ends up being a wrongful arrest for someone.
Okay, so let's talk about the wrongful arrest. We're talking about the drugstore incident with Kendra Christie, okay? First of all, Officer Rooney conceded that he used unnecessary force and that he was discourteous, and he took responsibility for those acts. The reason why he didn't cause inaccurate entries and did not cause a wrongful arrest is because there was another police officer from a separate police agency who testified at this trial who determined that it was a lawful arrest, and he processed that arrest.
Based on what Rooney told him.
Well, no, not entirely. Certainly based upon what Rooney told him. Sure, he didn't investigate.
Because this started in CVS. They were now on the street.
CVS, but it was based upon what Officer Rooney told him. It was also based upon what Kendra Christie said when she was on the scene. She was interviewed. And it was based upon an injury that was observed on Officer Rooney's hand. So the point is this: Officer Rooney is charged with causing inaccurate entries and causing a wrongful arrest. His own police department, who frankly was dissatisfied with their officer's conduct, decided, you know what, we don't want to prosecute this case, we want nothing to do with this. But another police agency, the Port Authority Police Department, decided, you know what, we think there's probable cause based upon our investigation.
They think that after watching the video?
The video was, okay, yes.
The video's problematic.
Well, look, but the answer to that question is yes. Because if you look at the record, originally Officer Rooney was put down as the arresting officer. And then the NYPD decided, we don't want to prosecute this case. And then the Port Authority, at the precinct where the video was reviewed, I don't know if they looked at the drugstore video, but they had Officer Rooney's body-worn camera video. And they decided, okay, well, you know what? If you're not going to process this arrest, we will. So they voided the arrest to take Officer Rooney out as the arresting officer, and they inserted as the arresting officer, Officer Isaiah Williams.
Officer Rooney says that Ms. Christie attempted to injure him and assaulted him, and the body cam doesn't show any of that.
The body camera shows, and during the trial, he showed the 3 strikes where she hit him with the bottle, okay? Now, here's the thing. Rooney said I was assaulted to the police officer. But he's not talking to some civilian passerby. He's talking to another police officer. That's what we in criminal law call conclusory language, right? That officer's like, well, the fact that you say you were assaulted.
So I don't want you, sorry, I don't want you to lose all of your time on that one case, because there are 2 others.
2 others.
It's 22-445, which is where he goes to his girlfriend's house, and he is unannounced, and he writes on the wall outside of her door, and then he says, I'm packing, you know.
Okay,
when he's, I don't know what he's talking about other than his weapon.
Yes, no, he's a police officer. He had a prior relationship with her.
Packing heat.
Right. She has been in and out of relationships with multiple police officers. And look, I'm not trying to say he exercised the best judgment.
Let's just get to, she has a prerogative, right? What she does in her personal life is up to her. I'm talking about what he did. He, knowing this, came to her apartment, called up repeatedly, annoying her, knowing that she was with someone else, comes to the outside, writes, certain things are accurate. He texts her multiple times.
Yes.
He writes on the wall outside of her door, and one of the texts he sends is that, don't worry, I'm packing heat.
Right. He thought it would impress her because she was an in and out of, I know it sounds crazy, but he thought it would impress her. During the trial, I made this point, right? When Romeo climbed over the garden wall, initially Juliet was annoyed, but ultimately she wound up with Romeo. Several weeks after this happened, this woman moved in and subsequently cohabited.
And so then we get to the next one, 23-895, where he says he's in Chicago, but she has a bruise on her calf.
Yeah.
And that doesn't have to happen the same day, because a bad bruise will remain beyond a day. And so she says that there is this altercation, and he intentionally injures her by squeezing her calf.
Okay, there's multiple problems with that. There's the one, if I may continue, that she gave 3 different dates of occurrence. and that the police department ultimately amended their charge to accommodate the fact that he had an alibi. He was outside the state during the first 2 dates that she said that it happened, and they stipulated to that. She also gives 2 different versions of how the assault occurred. At one point, they're just having a conversation on a couch. He gets up to leave, and he grabs her to stop her from walking away. In the other one, after it was reviewed by the Queen's DA's office, and they realized they needed a little bit more than that, it's he grabbed and then squeezed hard with the intent to cause an injury. So there's 2 different versions of it.
Okay, I'm going to let you to finish up on rebuttal.
Okay. Look.
That would be rebuttal when you.
Oh, I'm sorry. You might.
Yes,
I apologize.
thank you.
I misunderstood what you're saying.
No, that's okay.
May it please the court, Ian Sinclair for respondents.
Does termination here of Officer Rooney shock the conscience? Is it improper under these circumstances?
No, the decision to terminate was wholly reasonable, and there's 2 points of table setting I want to mention. First is that contrary to petitioner's reply brief, the guidelines are not rigid. They are not a promulgated rule. The first page of the introduction expressly says, nothing in these guidelines shall be construed to limit the discretion of the police commissioner to impose discipline. And the second is that Mr. Rooney committed a wide range of acts and pled guilty to many of them, including using unnecessary force, using discourteous and offensive language against civilians, neglecting to report those uses of force, violating paid detail rules, and misusing the departmental database, both of those last 2 things over a dozen times. So with that background in mind, termination here, even though it didn't need to, it absolutely comported with the guidelines.
Even though he's been an officer for 20 years?
Yes, because the presumptive penalty, just looking at things he pled guilty to, exceeds the 90-day threshold that kicks in a new presumptive penalty of termination. Not to mention the fact that he pled guilty, again, to aggressive physical altercations, use of offensive language, both of which, in an aggravated offense context, carries an individual penalty of termination. So here, the hearing officer, the deputy commissioner for trials, looks at the totality of evidence, looks at the disturbing lack of impulse control, and in the context of, as the Court of Appeals described in Purdy, the unique and sensitive roles of officers in civil life, termination here was more than fair and reasonable. I'll just briefly reiterate what your honors were getting at earlier, is that, again, the threshold question here is only whether the challenged convictions are supported by substantial evidence, meaning there's a reasonable basis in the record, regardless of whether this court might have come to a different conclusion. I think it's clear that in each of the 3 cases, there was, based on in-person testimony, documentary evidence, the body camera footage, and what the hearing officer found to be credible hearsay testimony, that weighing all those factors, that the record was ample.
Thank you.
If there are no other questions, I ask this court to affirm.
Thank you, Judge. So in terms of shocking the conscience, I first want to say this. The police department never should have gotten involved in the first incident. The first incident was a romantic entreaty that eventually was successful. As for the second, the complainant in that case, there were multiple cases, I cite them, Murphy and Ingram. There were many times in these circumstances where reliance upon hearsay testimony without the opportunity of cross-examination denies an individual a fair trial. And the Administrative Code 14-115B clearly says that police officers are not to be dismissed except upon written charges after a fair trial based upon rules and regulations or standards and procedures that the police commissioner, him or herself, actually promulgate. The police commissioner gave us those guidelines and they're in evidence, I believe, as an addendum, but also as Exhibit 4. And the trial commissioner in this case did not go according to those standards. Now, as for whether it shocks the conscience, you know, the guidelines don't exactly say, well, we just start adding up the days on every presumptive penalty until we hit tilt, all right? That's not really how it works. There's a lot of discretion with regard to how to manage these things. There's also supposed to be, according to those guidelines, consideration of mitigating factors. Officer Rooney had been a police officer for 20 years without incident. No incidents with civilians, no incidents within the police department. He hit a rough patch of his life, that's true. A big reason for the rough patch was this woman who made these allegations against him. Are
you blaming the woman?
What's that? No, 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 no. I'm not blaming the woman. But the fact of the matter is the allegation that she made against him regarding the bruise, her testimony is simply not credible. That's not blaming her. It's looking at the.
Why isn't it credible? Because she didn't remember the actual date?
Well, first of all, she wasn't there. She wasn't able to be cross-examined. She wasn't able to remember the date, even though on the videotape, they show her looking at the metadata on her phone because the assault happened 2 weeks prior to ascertain the date that the picture was taken. We all have these phones now. It tells you the date that the photograph was taken. She ascertained the photograph was taken on August 2nd. That was the date after the assault happened. Therefore, she concluded the assault happened August 1st. But it turns out Officer Rooney was in Chicago on August 1st. And the police department conceded that fact. So they said, okay, we'll make it from August 1st through August 4th. If you agree with me on 2 or 3 of these things, maybe not all 4, but I submit to you, if you give me some of it, I submit to you, you got to return this to the police department to have them ascertain a new penalty based upon the allegations that remain standing. I thank you all for your time. Have a great day.
Thank you both. People versus Richie Rivera.
Good afternoon, Your Honors. When the plea court
I'm
heard...
sorry, did you give your notice of appearance?
I apologize, Your Honor.
It's okay.
Sarah Siegel for Appellant Richie Rivera.
Thank you.
When the plea court heard that an assailant threatened Mr. Rivera and then shot him, it wanted to talk about self-defense. That was the right thing to do. Mr. Rivera had never been in any kind of trouble in his 39 years of life. Prior to being arrested for possessing a gun, he said he had used only to try and fail to deter the man who shot him nonetheless, inside his own apartment building. The problem is that when the court started talking about self-defense, it misstated the law.
Is it a misstatement for the court to say that there's no self-defense to criminal possession of a weapon, where the defendant possessed the illegal weapon with against someone who's unarmed? I mean, it's one thing when you possess a weapon because you're facing equal deadly harm, but he's pointing it at someone who is unarmed. Is that wrong, what the court said under those circumstances?
So thank you for the court's question. It points to 2 problems. The first is that temporary lawful possession is the name that we give self-defense to a possessory crime. And the court just seems to proceed as though that doesn't exist. The court does inquire of the prosecution.
That defense doesn't only relate when it comes to self-defense. I can imagine other instances where lawful temporary possession is a valid defense short of self-defense, right?
That is correct, Your Honor. But certainly self-defense is at the heart of one of the versions of temporary lawful possession. It's actually what the genesis for the Court of Appeals creation.
One of the primary tenets of self-defense is that whatever you're defending against has to be contemporaneous, right? And here we're talking about an incident that happens, correct me if I'm wrong, at least an hour after the defendant pointed the gun at this group. So how does that trigger to the judge, despite the fact that I think he did think about self-defense, but did he have to? Is this really is this truly a self-defense case?
I wish that we knew. The point is that the court did not inquire.
Do we know enough to know whether the court had an obligation or some obligation triggered to inquire further, right? We do know that the defendant was pleading guilty to pointing a gun at a group. We know that an hour after that, right, the defendant was shot by someone that apparently was in the group. That's what we know.
Forgive me, Your Honor. My client did not plead guilty to pointing a gun at someone.
Right.
He pleaded guilty to the misdemeanor.
Of a firearm.
Yes, the misdemeanor attempted criminal possession of a firearm.
It stems from that conduct.
Yes.
Okay.
Yes, it does. When the court questioned about self-defense, it mooted any question whether it had to. The point that is raised both by Your Honor's question and by Your Honor's question is that we don't know the answers to these questions because the court only inquired of the prosecution. The court's job is to ensure that the defendant understands any possible defense that he may have, not any valid defense, because Lopez says that the point of
Any defense whatsoever, even if it's inapplicable?
the point of a Lopez inquiry, quote, is to determine whether there existed a viable defense. After the court has raised the possibility, that language, the possibility, is the trigger for a Lopez inquiry. When the court
And I think that's why I'm challenging you. The fact that the court inquired that doesn't mean that the court thought that that was a viable defense.
And nor does it have to. The point of the Lopez inquiry itself is to determine whether there is a viable defense. You have to do that inquiry in order to find out whether there is one. The trigger point to require an inquiry at all is
Are
the
you
mere
putting it
possibility.
backwards? Doesn't the court have to have some information before it that gives it the impression that it now has to ask further questions because it's a possible defense? It can't be that you're saying that when the court is taking a plea that the court has to go through every defense known to see if it fits this case.
Certainly not, Your Honor. The point here is that the court undertook that inquiry and then did several things that really incapacitated Mr. Rivera's ability to understand the law that applied to him. The first was that the court simply misstated the law, said that there is no self-defense to a possessory crime, meaning self-defense is irrelevant here, when instead it is at the heart. Your Honors are completely correct that we don't know enough on this record to know whether there was a viable temporary lawful possession claim, and that's because the court didn't inquire of Mr. Rivera. Instead, the court only inquired of the prosecution with respect to the prosecution's version of events. That's not the question.
Well, the defense is right there. Wasn't he the defendant represented by someone?
The court's, yes, he was.
And so
and the
no
court's
effort to give the court the defenses that his client had?
No, and he didn't have to under this court's recent ruling under People v. Dupree, discussed at length in the reply, which specifically held that a Lopez claim will lie even if the defense is given up a specific opportunity to speak and says nothing, declines the opportunity. The point is that here, where the court is operating under a misunderstanding about what the law is, under People v. Dupree, People v. Lopez, and People v. Warden, which is cited in our papers and which I would encourage the court to look at, that where the court misstates the law, we can have no confidence that the defendant, here completely inexperienced.
You say misstates, and I still have a disagreement with your statement that the court misstated, because I don't see how the court misstated the law when the court simply said that there was no self-defense to criminal's possession of a weapon, because there isn't. Unless they were in a tussle and he retrieved the gun from somebody. I mean, it wasn't that. It was he was under the circumstances of what the court knew and what the defendant knew. It was he was pointing the gun at unarmed people. And under those circumstances, that was the context in which the question was asked.
I would only make a couple of points, Your Honor, if I may. First, what we know from the events that night is that at least one of them was armed, or at least had access to a weapon because he shot Mr. Rivera.
At the time that he pulled out the gun, no one else had a gun that they were pointing at him.
That's true. We don't know whether...
Okay, so from that, we can't conclude that anybody was armed. No one said, I have a gun too, and I'm going to pull it out and use it. There was none of that. We just know that from the video, he took the gun out and he was holding it at people who didn't have guns out.
That is true. What we also don't know is anything that happened before the video or after it. The video is quite short. And so we don't know because the court didn't ask Mr. Rivera, well, when you say that this man threatened you before that happened, did you think he had a gun? Why did you think he had a gun? This was in your building. Is this somebody you knew to have a gun?
Well, the later part was in the building, not the part on the street where he points the gun at the person.
It was directly in front of the building in the curtilage, Your Honor.
Thank you.
Thank you.
Good afternoon. May it please the court, Aiden Sanchez for the people. Your Honors, in this case, the court was not obligated to engage in a Lopez inquiry. A Lopez inquiry is triggered where the defendant's factual recitation negates an essential element of the crime that is charged. Where the defendant's recitation clearly casts significant doubt upon his guilt or otherwise calls into question the voluntariness of his plea. And that is simply not what happened in this case. The defense is honing in on an exchange between the court and the prosecutor where the court is presented with the fact that the defendant was shot at.
Counsel, if the court gleans that information from the prosecutor that establishes a potential defense for the defendant, you're not saying that the court's not obligated to follow up.
Not in the circumstances that you described, Your Honor.
I just want to make sure that, because what I think I heard you say is that the information has to come from the defendant.
No, it does not necessarily have to come from the defendant, but what does have to happen is that the information casts significant doubt on the voluntariness of the defendant.
So in this case, whatever information the judge had, it prompted him to follow up in a very limited fashion with the prosecutor. Why not follow it up with the defendant?
Well, simply in this case, the defense that the court raised, which is temporary voluntary possession, does not apply, as Your Honor mentioned before, self-defense does not apply to criminal possession of the weapon. Self-defense applies to the use of the weapon, but not the possession. The temporary possession of the weapon applies where, for example, a person finds a gun on the street and returns it to the police station, or
someone's going to use a gun unlawfully against you and you disarm them.
Exactly, but that's for the possession, not for the use. And during the plea, the court asked the prosecutor about the information that the defendant was shot and says, the defendant was shot, was that a part of this case? And the prosecutor replies, laying out the facts of what happened. It was originally defendant who took a firearm out at approximately 1:56 a.m. He was shot at 3 a.m. And the information that we have is that, and this is where, when you read the transcript, it's unclear, but when you say, it's clear what the prosecutor was trying to say, that he was shot by the same individual who defendant previously aimed a gun at.
Now, obviously, this discussion, which the prosecutor was being involved, it was more the judge seemed to be asking the prosecutor, and it was a conversation, but the defendant was right there.
Correct.
And the defendant just never said anything, Judge, I'd like to add to that, or I don't think the facts are correct, or they didn't respond. I mean, they weren't not permitted to respond.
You're correct, Your Honor. No, they did not respond. No self-defense or other defense was ever raised, and nothing that the defense or defendant said negated that he did, in fact, possess a weapon, which is what he was ultimately convicted of. Unless there are any other questions, I would just briefly note that as to the sentence, the defendant's probationary term is set to expire April 18th of this year, only in about 5 weeks. Just another factor for the interest of justice in this case.
Counsel, do you believe the defendant validly waived his right to appeal?
Yes, I do, Your Honor. The court's colloquy here mirrored the model colloquy, which the Court of Appeals has endorsed. It ensured defendant understood that his trial rights were separate and distinct from his right to appeal, confirmed as much on the record, and that defendant had discussed the waiver with his counsel, and that defendant executed the waiver in open court and in the presence of counsel. All those factors play into his voluntary plea.
Thank you.
Thank you.
Thank you. Just briefly on the point that the defendant himself didn't raise an issue, because the court had this, what I will call at least misleading statement, in that it did not admit of the possibility that self-defense could be relevant to a possessory crime. There's no reason to suspect the defendant could have known that there was a relevant self-defense issue here, or that self-defense was relevant to his case, because the court had just told him it's not. And also under People v. Dupree, this court's ruling, as well as People v. Ward and the Court of Appeals ruling, there is no requirement for the defendant himself to say anything. And I do just want to briefly emphasize that the Lopez inquiry is required upon the mere possibility that a defense exists, and that whether or not the defense is viable is something for the court to explore with the defendant, to explain to him that this is a defense that, the possibility is raised, but it wouldn't be right here for the following reasons, after having had a factual inquiry with him. All that was required here was for the court, having itself raised the possibility of defense, having undertaken that duty, to talk about it with the person whose understanding mattered, Mr. Rivera's. Mr. Rivera had never been in trouble before and was being told by the court that whatever self-defense, his 71031...
Counsel, when you say that the court itself brought up the defense, what I understood the court to be doing is to get clarification, right? Because what the court said was, the court asked whether the defendant had pointed the gun at other individuals when he was being shot, right? Because if that's the case, if you point the gun at another individual as you're being shot, then of course, self-defense is completely viable, right? But once he got the response that he was shot an hour and 4 minutes later, approximately, from when he pointed the gun, that did away with whatever he was thinking. So he satisfied whatever he was thinking in his mind, that the defense no longer applies. So why should he have to inquire further? Second part to that question is, was there anything at all in that exchange that challenged the notion that he was shot over an hour after he pointed the gun at the group?
To answer Your Honor's first question first, whether the court satisfied itself in its mind is not the question.
No, it is the question if you're saying that now the court is triggered to ask questions, right? Because that only comes if there's a viable defense, right? If there's a possibility of a defense,
Yes.
that only comes into play there. And under the facts here, it wouldn't be unreasonable for the court to think if you're claiming self-defense because you got shot an hour after you pointed the gun at the group, that's not a possibility of self-defense.
Your Honor's question again points to the fact that the court only relied on the prosecution statements of what happened. And so we don't know, because the court didn't ask Mr. Rivera, is that your claim? It never asked. And so we don't know. The court may well have satisfied itself based on the prosecution's version of the facts, but what we need here was clear evidence that Mr. Rivera had satisfied himself, that he understood the defense and wished to waive it, because the court was advising him that it really wouldn't fly on his version of the facts, because Lopez requires further inquiry to make sure that the defendant's story squares with the crime to which he is pleading guilty, not the prosecution's. And particularly where there is this close, apparent, at least geographical relationship between the assailant and my client's home, which contained his disabled minor son, for whom he is a single father. There is a real question about what was going on here, because the people candidly admitted during this allocution that they did not know how this dispute had begun. We don't know what kind of prior threats there were. We just don't know, and we don't know because the court did not inquire of my client, who had never engaged in anything like this before, which really should have prompted further inquiry about what the heck happened here.
Thank you. Thank you both. Assad Technology versus CNY Construction. Just a moment. So you have a cross appeal, and I think I gave you 7, 1, and 7.
7-1, and my understanding was 7.
7, but you have a cross appeal, so you get 1.
Okay.
7, 1, and 7, 1.
Yes.
Just a moment.
Thank you very much, Your Honor. Robert Howard, Rich and Telesano and Katz, on behalf of the defendant, appellant, respondent. I'd like to begin by referring to a telling internal email that was cited on page 25 of the reply brief, where on Facade, they're talking internally about what to do in this case. They're talking about how this $21 million contract has already been paid out. They're talking about how they'll lose money if they finish this job. They're talking about how they'll lose leverage against the owner to renegotiate a new deal if they continue working. And at the end, they say, well, rather than we'll lose more money if we finish, we're better off, quote, walking away.
Okay, let me focus you in a little bit as I have a question. And
Sure.
So let's start with the substantial completion, because there are lots of questions here. And I wonder why some of these just aren't questions of fact that need to go to trial or something else. And one is with regard to substantial completion, which I think you raised, substantial performance. Yes. And why isn't that, as the trial judge, the judge below said, why isn't that an issue?
The weight of the evidence here is overwhelming. There were multiple engineers and experts on even both sides of the caption, and even the owner's independent engineer have all said that this facade leaks. There's no contention even by Facade Tech that the facade doesn't leak. Heitman was the owner's independent engineer responsible for reporting to the Department of Buildings about whether the facade is sufficient to pass inspection for purpose of a certificate of occupancy. Said, no, we're not going to approve it. We're not going to sign off on it. There were even subsequent reports that repairs were not made. That's the owner's engineer. Of course, there's Socotech, which is the CNY's, the general contractor's expert. Moreover, there are.
So far, you've just gone through a number of different parties with a number of different issues and a number of different facts, which makes me think even more that this is a case for a trier of fact. Or this issue, at least.
This issue is not, and the reason is this, because there's two provisions that are specified for substantial completion in the contract. One is the work has to be conforming. It has to be consistent with what we planned. It has to be non-defective. It can't be defective work. And the contract specifies specifically that CNY is the judge of whether the work is good and sufficient. And under...
That's true, but that can't be arbitrary. It can't be just...
Absolutely. It cannot be arbitrary, but it's not arbitrary. Given the weight of this evidence, not only Heitman, not only Socotec, Fassad's own expert testified during his deposition, laid out in the briefs, that there were leaks, that the work was non-conforming, and there was no evidence from anyone by Facade Tech that there's no leaks, there's no evidence that the work was conforming, and given the weight of the evidence and the...
In the definition of substantially complete or substantial completion, it makes reference to obtaining a certificate of occupancy.
What it says is that the conforming work must be sufficiently complete such that the owner's right of occupancy, that's the second requirement under the contract, such that the owner's right of occupancy is not interfered with or hindered. And I've already told you that Heitman, the engineer responsible for reporting to the New York City for the purpose of obtaining this sign-off, refused to sign off on this work because it was insufficient.
Was a certificate of occupancy obtained?
Not a permanent certificate of occupancy, no.
But they didn't require a permanent one to be.
A temporary one was issued, but the reason why a permanent one cannot be issued is because specifically of the facade. And there's no evidence to the contrary submitted by Facade Tech, which is...
I mean, was it important that in the papers, Facade claimed that some of the delays and the problems in properly performing his work was due to changes that you guys made during the course of the work going on, and also construction issues attributable to your mismanagement of the project? I'm not saying that there was, but that's a claim that he's made based on some of the testimony in the record.
None of those contentions are even relevant to the substantial performance issue, and the reason is very simple. This pleading is pled on the basis of substantial completion. It is not pleaded on the basis of excuse of performance. The arguments that you're referring to would be conceivably excuse of performance, but that's not what's been pleaded here. This is a due performance. They're claiming it's due performance. The issues that they're raising are really related to delay damages, having nothing to do with even if it had been pleaded, these are not issues that prevented on an impossibility theory that any performance whatsoever. So before I run out of time, I'd like to just turn quickly to the cross appeal. Their contention on the cross appeal, which is to dismiss CNY's claim, is that there's no standing, and that's just preposterous. At a time that the owners, 20 TSQ lessee, had title to the lease, they gave what's called a liquidating agreement to CNY, and that's effectively an admission by CNY that their subcontractor, Facade, breached their obligation to do the work in a conforming and proper manner, and they confessed that liability to the owner, and in exchange, the owner says, okay, I'll assign my damages, my cost of completion damages, and I agree, the owner agrees to take whatever is recovered in the lawsuit as compensation for that loss. It's a well-established procedure. There's absolutely routine as a matter, and Facade's contention is that 3 years after this liquidating agreement, duly conveying this interest to CNY was given, 3 years later, TSQ's interest was foreclosed on, and that as a result of the foreclosure, they lost the title and their rights were divested. But that's not the standard of damages. Damages are measured at the time of the breach, and they're not divested by a conveyance of title. And I've cited several cases in the briefs in the related insurance context. If you have an insured claim and you make a claim against the insurance company and you subsequently sell your property, you still have a viable claim against the insurance company on your claim because you suffered those damages at the time that you were insured. The same concept applies here. And and the last point on the cross appeal that I want to address very quickly is with respect to the de minimis claim, the claim of damages. Normally, a measure of damages happens at the time of trial. But here, under the textbook case of Jacobs and Young versus Kent, in order to claim a diminution in value, you have to have substantial performance, which is, of course, wrapped into the main point. You also have to have good faith. If you fell short of full performance in good faith, then maybe. But as I started to quote at the beginning of this argument, that email shows that there was a willful decision not to perform. It can't meet good faith standard to apply the diminution in value. That's the end of that. In addition, you have to show, like in Jacobs and Young, there was an argument that the pipe was not the proper manufacturer, and the cost of replacing was exorbitant, and the cost of the value to be gained was minimal. But that's not what we have here. We have a $47 million repair claim on a building that's worth $1 billion. That does not qualify. So in all, our position is that the CNY's claim should be dismissed. The counterclaim should be severed and continued to trial. Thank you very much.
Thank you.
Good afternoon, Your Honors. My name is Jason Copley, counsel for plaintiff, appellant, and respondent.
And can we agree on several easier points here? The easier points that you don't challenge there's no challenge to the dismissal of the certain counterclaims here, correct? The 5th, 7th, and 8th counterclaim.
Correct, Your Honor.
And you can't seriously challenge they're seeking dismissal of the cause of action under the trust or the lien.
Trust fund diversion.
Because there's no class action.
Correct.
Here, so would you acknowledge that that's a problem here?
I don't, Your Honor, only because there's case law that indicates that it's okay to only have a class of one where a class was unable to be formed. Here, Assad Tech attempted to form a class, and it was denied, actually, by Judge Ostrager, and it can be maintained as an individual, and there's case law to support that cited in our brief.
Which case law? Are you talking about the case law in Supreme Court, or are you talking about the case law in the appellate divisions?
I believe it's case law in the appellate division, second department.
Well, the first department in Pizzarati makes it clear that the lien law counterclaims, I'm quoting from it, if they were not brought as a class action, then you can't have a claim to support it.
The class was brought at the time, and it was dismissed as a class.
Well, because you didn't have a class, because the earlier decision made clear that each of the subcontractors have their own unique set of facts. You understand that you need typicality, numerosity, the usual criteria under the CPLR. That didn't exist here, and you didn't plead that. But so there can't be a class. If there's no class, there can't be a cause of action under 3A of the lien law.
Again, there are cases that support that the cause of action can be maintained as a class of one.
Well, I asked the question because I think the only thing I saw was a Supreme Court case, which this case, Supreme Court doesn't hold here. This is the appellate division. Obviously, you know that the appellate division takes precedent over that.
Did you take the position below that they signed off on 100% of your work and that you actually met the contract terms, that there was a TCO, the building was occupied as a hotel? Am I correct?
Absolutely. The TCO, which is in the record at 5248, which was issued in June of 2019, after the hotel opened in April of 2019, the hotel has been in continuous operation since that time. And while there was leaks during testing in late 2018 before Facade was terminated, that was in one specific area at the window wall. And I'd like to point to the record at 5222, which is where Adam Aspero of Assad Technology complains very specifically to CNY, I can't install the way you want, essentially, because the curbs are bad and I'm going to get blamed later. I don't know what clearer evidence there could be that Facade didn't want to proceed, but it was directed to do so with a repair that Facade didn't believe would satisfy Heitman, the same party the council just referred to.
Counsel, if you believe you completed all the work, then how do you possibly have a cardinal change doctrine cause of action?
We're not maintaining a cardinal change. We're
So then your fourth cause of action should be dismissed.
correct. We believe breach of contract is our claim, and we also believe that quantum merit is viable depending on an alternative theory of damages. So there are two theories of damages pled. One is for breach of contract and for payments under the completion agreement, funding facade through completion. And the second is a total cost claim, which is more of a quantum merit.
On this record, what are the Carino exceptions that you must rely on to get around no damages for delay?
Absolutely, Your Honor. The biggest is the removal of the hoist in bad faith by CNY. And for that, we rely upon an email, which is internal to CNY, and that is at the record at 2971. And in that email, Ken Kaleo, the president of CNY, says we're not going to remove the hoist. And he further says, I agree with you guys in response to we shouldn't remove the hoist. Unless they are willing to sign a scope change, the hoist stays. We are not bound by their retail agreements that they never officially brought us in the loop. We should also officially advise subs of schedule changes. Otherwise, it's a trap. It could potentially be used by a sub claim that we knowingly were working to a much later date and essentially avoiding acceleration claims. They didn't notify the subs. What they did, though, in two other places in the record, was they notified the owner that there could be scope changes and damages exceeding $2 million for delay. That is in the record at 5231, and also in a progress report from CNY to the owner and the record at 5021. These are admissions by CNY that it knew that the removal of the hoist that was specifically owed to CNY in its contract in the record at 87 in paragraphs 23 and in paragraph 19 in the record at 101. So these acts, I want to turn to our affirmative claim to dismiss the claim based on of CNY because the owner doesn't own the building anymore. It's foreclosed on and they lost possession, right, title, and interest in it. And in fact, they went to a hearing on a deficiency judgment where they put before a court that the building was in excellent condition and they avoided a deficiency judgment. They have an empty hand. If they're awarded money in this case, it's going in their pockets. It's not being used to fix the building. They're dispossessed. So how can they get an award of $47 million to repair a building that they never will? CNY, while it says it admitted liability for leaks, it also was released in that very same agreement and is here because it is in a sharing agreement and is going to get a fee if in fact it does recover. That's not real damage. This owner, 20 TSQ lessee, will never spend $1 repairing this building. That is not a valid claim, especially when they have already come to court and said that the building is in excellent condition.
Thank you.
May I reserve an extra minute since I'm done now to respond? Okay. Thank you.
I don't know that you have an extra minute. Actually, you have about seconds, so let's see how that goes.
Okay.
Counsel, could you address one of the last points you just made about the remediation, since you no longer, about the remediation damages, since you are no longer in possession and you lost the, whatever, you're no longer in possession, would you be entitled to these remediation damages, which is one of your counterclaims?
Absolutely. And the reason is because the cause of action accrues at the time of the breach. That's when it accrues. Just like the insurance claims, when the claim is made and the loss is incurred, that's when you have a right under the contract. And the case law is very clear from this department that events subsequent to the accrual of that claim do not divest a party of standing to recover.
But you never, I mean, you would not be the ones that do the remediation, so it doesn't make sense.
It does, and the reason, it's theoretical, but let me explain. So this property was sold at auction. It was sold with all faults. Whatever faults there are, this property was sold.
Take it as it is, huh?
It's as is, exactly. There's no permanent certificate of occupancy. That's the loss. The loss is my property doesn't have, because of these defects caused by a facade, the property doesn't qualify for a permanent CO, and that's where theoretically the damages is. That's why at the time of the breach, that's when the damages accrue. And if I could just, 30 seconds. 3A claim is not viable because it has to be as a class action. Why? Because those claims are for the class. There's no individual standing. And I think the case law recited, there's no individual standing. The TCO is not sufficient under the substantial completion doctrine. You want as an owner, it's all about getting the permanent certificate of occupancy. A temporary certificate of occupancy just means you got more work to do. They're just letting you use, cities letting you use the building for now, but they're holding over your head the threat of not renewing that TCO, and then where are you? This building has to be repaired. It has to be, that's not sufficient performance under the substantial completion standard. And I want to talk just 2 seconds about the hoist. CNY did object to the owner who insisted to the removal of the hoist because they're losing millions of dollars. This is an undeveloped, they're spending all this money. They need to generate revenue. What they said to CNY was, hey, we want to rent out a commercial space. You need to remove this hoist so we can lease some of this space. CNY certainly objected, but when the owner who's paying the bills says we need to remove it, you got to remove it. And that flowed downstream, but that does not qualify as a bad faith under the moral turpitude, the exception under Sereno. That's not bad faith. That's doing what we have to do in order to get the project over the finish line. Thank you.
It certainly is evidence of bad faith, and it deserves to go to the trier of fact. As I stated, there's clear information in the record that shows that CNY knew that it would damage subs. And you just heard, well, they had to do it so the owner could make money on a lease, and it would damage subs. But what didn't happen was that this contractor, CNY, said to all the subcontractors, the owner is going to have to pay these damages, and the owner is going to have to be responsible for the added costs. And instead, they didn't tell the subs, and they continued to force the subs to perform to completion as soon as possible under very difficult circumstances, which is clearly bad faith, or certainly the opportunity to prove bad faith at trial. Second, with respect to the foreclosure, this owner, 20 TSQ, which will never repair the building, successfully convinced a court that the building was in excellent condition so that it could achieve and avoid a deficiency judgment. The judgment was, they were looking at hundreds of millions of dollars of deficiency, both as 20 TSQ lessee and Mark Siffin individually. And by presenting evidence to the court that the building was in excellent condition, it avoided a deficiency judgment when the court determined it was worth over $850 million. You can't have it both ways. So 20 TSQ now can't come with an empty hand and recover $47 million for a building it will never repair. And clearly, the cause of the leaks and the extent of the leaks are a hotly disputed issue for a jury or the fact finder.
Thank you. Thank you both. People versus Jesse Noel and People versus Ricardo Ciani.
Good afternoon, Your Honors. Dana Poole for the People. In these cases, the people are asking for reconsideration of the court-created doctrine of abatement ab initio.
So you know that we have the Court of Appeals case of Mintz, decided in 1967, again affirmed later on. So this, I guess, is a way to go from here to the Court of Appeals because you understand that we are constrained by Court of Appeals precedent.
Right, and we understand that under the doctrine of stare decisis, that doctrine can be reexamined. But even if this court decides it is absolutely bound by Mintz, which I suspect it will, it still has an important voice in this matter. This court, in addition to dealing with any number of types of criminal cases on a regular basis, especially those involving victims, has also dealt with the probity of a conviction that is not final due to the defendant's death. And in that case, Pickle or Pikel, not sure, this court found that the conviction does not lose reliability. It is still presumptively reliable, even though the defendant did not have the opportunity to complete a direct appeal. And in that case, and that ruling comports with the sort of reliability, the presumptive reliability of a conviction, which in most cases involves a defendant beginning to serve a sentence long before he even has an opportunity to file a notice of appeal, let alone complete a direct appeal. And this court, through its experience, not just in that single case, but in routinely seeing the abatement motions and issuing abatement orders, my own experience would say you probably receive 1 or 2 a week. And this court
I wouldn't say there were that many, but I'm more concerned about your view that we should be speaking about an issue that we are bound by case law on, which I don't see that these facts present such different facts than we have seen in other cases where the sentencing doesn't take place. There is a victim. There is usually a victim. And I don't see how we speak on that.
Well, Your Honor, just like the justice.
I do see how this gets to the Court of Appeals for them to decide.
Right, and it may be as simple as that. But this court also does have the power to offer its experience, just like the justices.
That would be an advisory opinion on facts that are not before us that change what the Court of Appeals has. But I'm going to go ahead and let you make your argument.
Thank you, Your Honor.
Or finish your argument. Go ahead.
Yes. So even this court, just like the justices below, can grapple with these issues. This court has experience that is relevant to this question. And this is an odd situation in which this is a court-made policy for how courts deal with certain situations. So certainly the fact that courts who experience this, who deal with these issues, are in a position to weigh in, even if not make the ultimate decision. And what we're coming to this court
So it's more than 7 judges who should be deciding this issue that is set by the Court of Appeals right now.
Ultimately, the Court of Appeals will make the final determination, where I'm not trying to pretend that is not the case, Your Honor. I am urging, though, that this court still retains an important voice in that conversation, just as the justices below, who ultimately ruled that they were...
If the facts were different here, but they're not. You're asking us to make a policy decision that is different from essentially policy being the decision of the Court of Appeals. You're asking us to say something that is different than their case, to go against the precedent.
What we're asking
without any facts that are different than that's been set by the Court of Appeals in numerous.
The facts are different in that a party is asking for consideration of the inherent dignity of victims of crimes.
That's been done before.
And that has not been directed to the court before. That was not part of the Mintz case. It was not part of the Madison case. And so what we're asking is to deal with an aspect of this policy that has yet to be addressed other than by lower courts, particularly in these 2 issues. But yes, ultimately we anticipate that we will be trying to get this case up to the Court of Appeals. I see my light is on. Thank you.
Good afternoon, Matthew Bova for court-appointed amicus here. I think the government has basically conceded that Court of Appeals precedent binds this court and defeats their argument here. The way to do this is to file leave application with the Court of Appeals. I'd also say, as a matter of this court's policy, having full-fledged briefing and then having a party come before this court and basically say, yes, we ultimately agree this is going to be settled in a leave application, is just not the right way to go about doing this. I mean, the government does not have to seek full-fledged briefing here before raising an issue in front of the Court of Appeals. The Pickle case is easily distinguishable because in Pickle, this court just basically said that as far as the collateral estoppel effect of a criminal conviction in civil litigation, that still applies despite abatement. But that case specifically affirmed the doctrine of Mintz and Madison that in the criminal context, you still have abatement and indictment dismissal when the defendant dies during the pendency of the appeal. And as more broadly as to this theory of stare decisis that the state is trying to pigeonhole in here, I think the argument is because they can think of an argument that may be worthy of presenting to the Court of Appeals, this court somehow has the power to consider that argument and then overrule the Court of Appeals. That throws the hierarchy on its head. That's not how stare decisis works, and this court nor the Court of Appeals has ever endorsed such an approach to appellate litigation. Unless the court has any questions, thank you.
Thank you.
Counsel, are you in any way insinuating that we have the power to overturn Mintz?
We're not saying you
I
have.
didn't hear you to say that, but I just want to make sure.
So what
Right.
are you saying?
We're saying we do believe that this court is, we do have to go through this court to get to the Court of Appeals on this issue. There's no question about that. We don't agree that we have to treat this court as a mere way station on that path. We do think that this court has the power to opine on this issue, even if they are
How is that not advisory? This court is not in the business, nor should it be, of giving advisory opinions. We have always practiced not to give advisory opinions. So how would it be different here if we did what you wanted and gave an advisory opinion?
Your Honor,
if we say that Mintz controls, it goes to the Court of Appeals. You'll appeal. It'll go to the Court of Appeals, right? Or you'll get a leave application, or they'll grant it, or it'll be given from here, and you'll go there, and it'll be for them to do. Your office is here often. Never before would you be defending the defense for wanting us to give an advisory opinion on an issue that is set in the Court of Appeals.
Well, then, Your Honor, we will be seeking leave, and we simply
That's
are
your right
respecting that
seek leave.
this court is on that path, and we do not have the power to work around this court on that path, and hence we have come before you. Thank you.
Saunders versus Fauci.
Good afternoon, Your Honors. Joseph Jacobs from Prior Cashman here on behalf of Appellant John Saunders. Your Honors, this is a straightforward breach of contract action arising out of Respondent's failure to pay amounts due to Appellant under the terms of the contract between the parties.
Would you agree that the earlier appeal pretty much gave you a complete win here and the court was wrong below?
Yes, Your Honor, I do.
So you're just trying to enforce the attorney's fees that your client is trying to enforce the judgment that it received from this court that was never satisfied, and you're looking for the attorney's fees that have accrued in trying to enforce that judgment since May 1st of
2020.
2020.
Slightly different, Your Honor. So that the previous action, there was a judgment entered which awarded attorney's fees through and including April 30th of 2020.
Right.
These are after that.
These are after the
Right, that's what I'm saying. From May, sorry if I misspoke.
Judgment.
Sorry?
It's not an unsatisfied judgment. The judgment in the previous action only dealt with the time period ending.
Right,
April
yes,
30th.
no, the other judgment.
Yes.
You are going from May 1st for attorney's fees from May 1st, 2020, coming forward.
Correct.
And you have a judgment on what happened before, because I was on that appeal.
That is
with
correct.
regard- Exactly. If I misspoke, I didn't mean to.
I apologize.
So the whole concept of res judicata and collateral estoppel were never discussed by the Supreme Court judge, correct?
No, Your Honor. The issue was raised in our papers.
Right, you
and
argued
that oral
it.
argument, of course, but no, it was not addressed in the lower court's decision.
And based on both of those, I think you argue, you are certainly entitled, I mean, you are claiming that you're entitled to win this time like you did the time before.
That's right, Your Honor. And the reason there is because the arguments that were raised in opposition to our motion are exclusively arguments that were previously raised and addressed and decided against the respondents and in favor of my client by both the trial court and affirmed by this court.
So res judicata really doesn't play a role in this case, is what you're saying?
No.
Res judicata and collateral estoppel issues with regard to what you are seeking here does not play a role.
Not with regard to what we are seeking. However, those doctrines bar the arguments that were raised by respondents in opposition, as well as the finding of fact by the court that was based exclusively on those arguments that were previously raised and thus are barred. And in addition, even setting aside both res judicata and collateral estoppel, the opposition simply did not address our showing or address the burdens or the claims in this action. The opposition is exclusively focused on issues that were previously raised and are not relevant to the issue of attorney's fees due and owing after May 1, 2020, which is a distinct and separate issue from the issues of my client's entitlement to a commission or the scope or extent of that commission under the contract between the parties.
Thank you.
Thank you. No more questions?
Good afternoon, Your Honors. May it please the Court, Charter Williams for defendant respondents. So there's a few inaccuracies in my learned colleague's presentation. This doesn't purely hang on the previous action. The previous action was integrated and based on the brokerage agreement. That's where they hung their entire case the first time around, and they still are today. So the prior action had been, the judgment had been settled from that action, and now they come back looking for another bite at the apple, essentially trying to get attorney's fees, and they're basing that right still on the previous brokerage agreement that was signed by my client and Mr. Saunders. Now, the issue here is that we actually had introduced additional information in our pleadings, in our affirmative defenses via our answer for this current matter, in which we brought up the issues that plaintiff appellant had unclean hands and there was culpable conduct. And that was all based on the fact that there was information that was not previously available to us that had become available in the interim between these two actions, okay? Which was, I'm sorry, Your Honor, you look like you have a question.
Well, I'm just thinking because in 2020, the representation agreement was what was considered, and it was considered in the context of the radio station and the real estate. You're saying it was separate, but that was something that you raised or the parties raised then, and it was rejected by the court. So
on the first time around, Your Honor? Or
I beg your pardon?
So
I'm talking about in the first action.
Right. The crux of it here is that in the first time around, I was not counsel at that point.
I'm not meaning you personally.
I understand.
Sorry.
But I'll just explain that first time around, counsel then for my client hung their entire case on the affirmative defense that the plaintiff was not a licensed real estate broker in the state. And so, Judge Leibowitz even confirms this in his decision, which I included in our brief, but if you'll bear with me, I'll just read from Judge Leibowitz's decision in the transcript. In making this decision, Leibowitz respondents made no actual challenge to appellant's motion for summary judgment. They simply raised the affirmative defense that plaintiff lacks standing to bring or maintain this action based on any cause of action because plaintiff is not a real estate broker. So there was no challenge to the actual underlying contract the first time around.
But the issue with regard to the brokers, with this being not being the issue that this was a real estate transaction was raised before. And so if there was an issue with regard to brokers' fees, it should have been raised in that action, not now.
And that was raised, Your Honor, but what was not raised.
So then it was rejected.
That was rejected. That's correct, Your Honor.
So then how are you bringing it back again?
We're not bringing that, actually, Your Honor. And the difference here hangs on the fact that we are challenging the contract itself. The contract was very ambiguous. It was a one-page document.
The representation agreement?
Yes, the brokerage agreement.
That's what was decided. It was based on the representation agreement before. So if you're saying there's something ambiguous in the very document that was considered in the prior appeal, it was that representation agreement.
Well, there was never challenged, actually, Your Honor.
Again, any issue or claim should have been raised then.
In the summary judgment proceeding before Judge Leibowitz, that was actually never litigated because the only issue that was dealt with there, because my previous counsel did not even raise these issues. All he was doing is providing his affirmative defense.
But there's a transactional approach. You can be bound by collateral estoppel even if you don't raise a particular issue, but you could have raised a particular issue then. Well, the bottom line is the earlier appeal, I believe I was on the panel with Justice Renwick, the commission is now a fait accompli. they're entitled to it. You take issue with it because A, licensing and all that other stuff, but that's over. So now this is an extension based on the judgment that's been affirmed. I don't see how you can get around that.
Well, Your Honor, in the preceding years since the initial action, I know I'm over on time, but if you could entertain me here, please.
The proceeding here, you're talking about the attorney's fees.
The attorney's
from May
fees
1st
stemming
to
from
now.
the first appeal before the court
Right.
here from several years ago.
Yeah.
In the interim, there's been information provided that really demonstrate the fact that Mr. Saunders had unclean hands in this entire transaction. He worked to try to basically create a better commission than he should have had in the first place because he was not, he was.
But none of the facts that you're saying here that are regarding that are things that weren't,
Yeah,
you know.
there is one thing, Your Honor. It's the testimony from Gary Sapien, who was the previous.
He was around before. He's a friend of the people who were selling he's the person who was selling the property.
He was the president of the previous company.
So he was there before. He
Well, but
he
his
would have
te-
been
but-
able to testify before.
Well,
So-
possibly, but my client was not privy to the information because there was no contractual privity at the time because he worked for the previous owner, the seller. My client had no reason to think that he had information regarding Saunders' interaction in the whole transaction structuring. Saunders really integrated himself into the creation of the broader contract in order to take advantage of the situation and be able to create a better commission for himself. And that previous testimony from Mr. Sapien was not before the court. And that's what Judge Adams at the lower court about this current situation, that's where she caught issue with that because there's material issues of fact that really need to be sussed out through either discovery or going to trial that were not before the court in the first time around. They were not before Judge Leibowitz. And that's what I'm trying to get at here. And I think that the Kaufman court and the Kaufman decision really reflects that, where these identical issues were not necessarily decided. So I think the counsel's argument regarding collateral estoppel and res judicata do not apply. And I would say that our answer in itself demonstrates that we are bringing in things that were not previously decided because we didn't know about
Even
this.
if that's the case, this action is for attorney's fees. That's what it is.
It all hangs on a contract, Your Honor, that is based on unclean hands is what we're saying, is that plaintiff, and we didn't have the information in the first go-around to even be able to raise the issues.
I don't see how you get to that through the attorney's fees that's based on an agreement that was already, there's a judgment on.
Well, it was ambiguous, and I think that's why we're here now. That's why this whole issue came up, because it was a one-page brokerage agreement drafted by two people who are not attorneys. There was no attorneys that reviewed from either side, and it was obviously ambiguous because it didn't speak to what happens with real estate, what happens with his interaction, what happens if there's 3 separate transactions, and that opened the door for Mr. Saunders to really put his foot into it and be able to develop the transaction in a way that would be most beneficial to himself. And that's what we're suggesting, and that's what we see that Judge Adams agreed with us there in denying the summary judgment.
Thank you.
So, thank you very much.
Very briefly, Your Honors.
Counsel, excuse me, was there ever a motion made by your friend to vacate the judgment based on newly acquired information?
No, Your Honor, there was not.
And counsel, weren't these similar arguments made in the prior?
Yes, if I may offer a few quotes from the respondent's briefing before this court in the previous action. So, in comparison to what's before the court now. Here, respondents argue, quote, appellant structured the deal in such a way as to ensure that he maximized his commission. That's from page 6 of respondent's brief. In the previous appeal, respondents argued that appellant improperly structured the transaction in a way to maximize his commission. Similarly, here, respondents argue that, quote, their current defenses and claims center on facts related to the representation agreement and appellant's actions surrounding the structuring of those transactions. In the last appeal, respondents argued that in ruling on defendant's motion for summary judgment and plaintiff Saunders' cross motion for summary judgment, the court placed its emphasis on the transactional structure of the 3 purchases made by defendants. So it's very clear that these exact issues were raised both before the lower court in the previous action and before this panel.
And we rejected it.
And rejected, and respondents moved for leave to appeal to the Court of Appeals, and that motion was denied.
It was denied.
It was denied, and that's in the record as well. So, in addition, with respect to respondents' argument that their affirmative defense somehow changes the calculus here, We showed in our initial moving papers that those defenses were all meritless. Respondents did not address that argument in opposition to our initial papers. Therefore, they've conceded the fact that those defenses are meritless, and they've waived any argument to the contrary. To the extent that respondents argued that Gary Sapien's affidavit and information provided by Mr. Sapien is new and newly discovered and somehow warrants reopening this case, as Your Honor has pointed out, that's simply not the case. Mr. Sapien's own affidavit testifies that he was in communication with multiple of the respondents as
During
early
the
as
previous litigation.
well before the previous litigation in 2018. And finally, if I may just make one final point.
I think we have your point.
Okay, thank you, Your Honor.
Thank you both. Mason versus NYU, New York University.
Good afternoon, Your Honors. Christopher Watkins on behalf of the plaintiff appellant Joshua Mason. May it please the court. The issue on this appeal is whether or not a reasonable jury can find that NYU referred Dr. Mason to the Office of Professional Medical Conduct, OPMC, and accused him of medical misconduct or professional misconduct with common law or constitutional malice. And I believe the answer is that a reasonable jury can so find. I think the analysis starts with the fact that NYU admittedly, or undisputedly I should say, did not review the alcohol, the patient who was undergoing alcohol withdrawals medical record. And there's no reason given by NYU for the fact that it did not review the record before it terminated Dr. Mason and reported him to the OPMC based on alleged misconduct with respect to the alcohol withdrawal patient.
So there were many issues raised here with regard to the doctor's behavior, and that he waited forever to get to the patient. He was called and he didn't come.
Right.
Those are also issues that were raised and were supported by the resident, by the attending nurses, and there was an investigation with all of those people taking part.
That's one version of the facts that a reasonable jury can find, but the medical record, the patient's medical record shows otherwise. It shows that, first of all, what Dr. Moe, the resident physician who Dr. Mason had previously raised concerns about, reported, almost all of it is completely contradicted by the patient's medical record, which NYU did not review, including the fact that when the patient was admitted to the ICU, Dr. Mason's area, Dr. Mason responded to the ICU, to the patient's bedside within 10 minutes. Within 10 minutes of the patient being admitted. That's completely contradictory to what Dr. Moe claimed in her patient safety intelligence report, the PSI. She also claimed that the patient was on the maximum dose of Precedix, a sedative, when in fact the patient was nowhere near a maximum dose of Precedix. She claimed that the patient needed to be intubated. The medical record shows that's absolutely not true. She claimed the patient was crawling on the floor in the ICU. The medical record shows that's not true. And we have a record that a jury can look at, namely the patient's medical record, and show that what Dr. Moe was claiming was not true. And for some reason, NYU chose not to perform the fundamental task when it's assessing whether a physician met the standard of care, chose not to review the medical record. A reasonable jury can find from that it was deliberately avoiding the truth or falsity with respect to the claims that it was making to OPMC about Dr. Mason. In fact, OPMC ultimately concluded there was no basis to bring charges against Dr. Mason with respect to anything, including that patient. So that is a deliberate avoidance of the truth. At least a reasonable jury can find that, and it is a fundamental step. I think we have an expert to say that. I believe defendants acknowledge that that's a fundamental step when you're reviewing whether or not a doctor has violated the standard of care. You look first at the patient's medical record. Malpractice case, the same thing. A lay jury could understand that, but an expert we'll tell them that. That's fundamental. And NYU did not do that. Why would it not do that? That's the question. And we allege, and there's support in the record, that it was based on its malice against or retaliatory animus against Dr. Mason because he had been reporting concerns, serious concerns, about certain of the resident physicians' failure to adequately care for patients, including Dr. Moe, the doctor who submitted the PSI report. So there, and the lower court, Supreme Court, found that there was sufficient evidence of retaliatory animus, including Dr. Rajmani's statement to Dr. Mason that if you continue to make complaints about certain of these residents, you're going to have a bullseye on your back. That's in June of 2017, a few months before he's then terminated and reported to OPMC for misconduct.
Well, you do have a claim, I think, that labor law 741 claim. That's different than what you have here.
It is different. The burden is lower because, at least with respect to common law malice, we would have to show, or jury would have to find that it was the sole reason for the OPMC referral and the statements therein.
Thank you.
Thank you.
Good afternoon, Your Honors. Michael Collins for the respondent, NYU. Plaintiff's entire appeal apparently hangs on and it is a fact that a medical record was not reviewed prior to the decision to terminate Dr. Mason. The reason the medical record was not reviewed is that this was not a medical issue, okay? It was an issue with regard to his judgment and an issue with regard to his responsiveness. No amount of review of a medical record is going to change the PSI complaint that was then substantiated by several nurses who were interviewed contemporaneously within 24 hours who said he was called multiple times, the patient was going wild, he didn't show up for 25 or 30 minutes,
So
and that was...
Is counsel's claim that he showed up 10 minutes later, that's not supported by the record?
It absolutely is not, Judge, as is
And that's
the
the
statement
medical
that
record? You just said that they didn't look at the medical record, so I'm saying, is that wrong that it said he appeared within 10 minutes?
I know,
Did the
I'm not
medical record say that?
We don't concede that the medical record shows that. He may make that argument, but there are affidavits from the nurses and the PSI, and that is all in the context of everything that came before that, right? Appellant wants to act as if Dr. Mason was, a model physician and had this one incident and he was terminated. That's not the case.
So you would say the backdrop to all this is the fact that he was placed on FPPE due to resident supervision or problems with resident supervision, patient care, and behavior.
Absolutely.
So because you're a teaching hospital, right?
And
attending has a responsibility to be able to teach the residents the best practices, and if he's not doing that job, that's a big problem for the hospital,
it was
correct?
a key part of his job and one that was one of the main points in the FPPE, and the residents were petrified of him. That's in the record. With regard to the operative statutory provision, right, and I think it's significant that the legislature actually passes a statute that requires a report when you terminate a position under a situation where there's any view that it jeopardizes patient safety. And the statute says, any person, facility, or corporation which makes a report pursuant to this section in good faith and without malice shall have immunity from any liability, civil or criminal. That's similar to the common law malice situation. What I'm coming to, I think, is the kicker and really elevates this to what I would call it really sort of elevates the standard for purposes, let me read the language, for purposes of proceeding civil or criminal, the good faith of any person required to make a report shall be presumed, right? So I would say that that makes it.
So you're saying Ms. Simon's letter to this agency on this was made in good faith, and there's a presumption that she did so because she had a duty to report.
Right, so I think it's sort of a heightened standard. It's malice or qualified immunity on steroids, I think is the way I would describe the presumption
That's
that's
not
in the
illegal.
statute. The other thing is with.
I just have to ask you.
Yes.
There is something. The letter is sent by the NYU representative to the Arizona hospital, and it says that the OMBC. I'm stating it wrong, but the OPMC investigation was closed.
Yes, it does say that.
It didn't say that that upon completion of the investigation, based on all the information available to this office, there is insufficient evidence to bring a charge of professional misconduct as defined by New York state law against Joshua Mason. Is that any suggestion? Well, so it doesn't have to be, it has to be more than a suggestion. Is that malice?
I'm not sure that you can sort of say that those are two things are substantially different, right? They may be slightly different, but saying that
Well,
the
they are
investigation
different.
the investigation was closed is not an inaccurate statement. That's
No,
number
it
one.
was absolutely accurate.
And the
but
second part is with regard to your question, Judge,
Exactly.
sorry to interrupt, is there's no evidence that Ms. Caclius, who this is now a year later responding to a specific request from the plaintiff to basically tell the Arizona Medical Board why I was terminated, had any inkling, knowledge, or anything about Dr. Mason. In other words, there's nothing that you can impute any kind of malice to her. And based on that, there's no reason that you can sort of.
So you're saying there would have been no reason under any circumstances to include the more complete analysis?
Well, from her perspective, it didn't matter, right? She was just trying to report based on what she knew and honor the request. The idea that she did this maliciously, there's nothing in the record that supports that.
May I ask one?
Okay, sure.
The fact that the matter was closed is a positive thing, not a negative.
Yes, it's definitely a positive thing. It's saying to them that
whatever was going on, there's nothing there, right?
Correct. That's why I said it was substantially equivalent, Judge. I agree it's different, but it's not defamatory.
Thank you.
Thank you. Just briefly, with respect to the patient, according to the medical record, was admitted to the ICU at 4:32. Dr. Mason was bedside at 4:42. That's 10 minutes. That's what the medical record shows, which they did not review. And the doctors who were leading the investigation, Dr. Rajmani, Dr. Volpicelli, Dr. Weiss, are all, there's evidence in the record.
Does it indicate who puts that information in the medical record?
The patient is given a dose or dosage.
No, I said, does it indicate who would have made that entry into the medical record?
I don't recall who made the entry, but the entry indicates that Dr. Mason was there because the patient was given Versed, which only Dr. Moe did not have privileges to administer to the patient. And that's consistent with what Dr. Mason said. In fact, it's even consistent with Dr. Moe's testimony at her deposition. But just briefly, I understand that there's this argument that it's teaching hospital, you have to be able to supervise residents. But if you look closely at the record, the residents who are complaining and who counsel says were terrified of Dr. Mason are the same residents who Dr. Mason, and there's just a handful of residents who Dr. Mason had reported for their own misconduct or for their own failure to provide adequate medical care, including Dr. Moe disappearing from the ICU while caring for a very ill individual. So if there are no more questions, we'll rest.
Thank you.
Thank you very much, Your Honor.
Thank you both. Vanguard Construction versus 400 Times Square.
May it please the court, my name is Victor Worms, and I'm the attorney for the appellant 400 Times Square. Your Honor, this is a case which seeks to reverse the lower court's decision of April 8, 2024, which denied 400 Times Square's cross motion for summary judgment to dismiss the underlying lien foreclosure action. It also
So
seeks.
the first lien is the one that was amended, but how is that first lien defective when the plaintiff doesn't dispute, your 400 doesn't dispute that, not the plaintiff, the defendant doesn't dispute that the lien law satisfied certain requirements. It had the price, the agreed upon price, it had the start and the end date, it had the value of the labor and materials, the owner's address, the name of the PIPS, the organization that was doing the contracting work, and it indicated lots 1501 and 1502. So that is, which were owned and managed the entire time by the plaintiff. So that is everything that they needed to know.
Well, Judge, let me just address that question. But before I do that, Your Honor, there is an anomaly here. And this anomaly is fatal to the plaintiff's respondent's case. And that is its failure to comply with New York lien law 11B. And because it's so critical, 11B, I'd like, with the court's permission, just to read the statute because it is dispositive of this appeal. It says, within 5 days before or within 30 days after the filing of a notice of lien in accordance with Section 10 of this chapter or the filing of an amendment of notice of lien in accordance with Section 12A of this chapter, the liener shall serve a copy of such lien or amendment by certified mail on the contractor, subcontract, signer, or legal representative for whom he was contracted to be the person, firm, or corporation. If this liener is also the contractor, he has to serve it. Now, 11B has a very critical language. It says the failure to file proof of such service with the county clerk within the 35 days after the notice of lien is filed shall terminate the notice of lien. This is critical, Judge, because what occurred here are two separate issues which should not be conflated. One, the court did grant the motion to amend non-proton, which I'll address with your question separately. But after it granted that motion, nothing happened. He didn't go ahead and file, pursuant to Section 11B, an amended notice of lien and serve it upon PIPS. He's required to do that. That's what the law provides. And if you fail to do it, it terminates the lien. So regardless of whether or not the lien was properly amended, his failure to do so is fatal. Now, to address your question, Your Honor, the lien was jurisdictionally defective because it did not substantially comply with the lien law. Section 23 says that a lien has to be in substantial compliance. If there's more than one defect in a lien,
it has to be construed liberally.
Yes, but it also must be in substantial compliance. And this court, in its decision of Diamond Architecture, Inc. versus EFCO Corp., 179 AD 2nd 420 says, if there's more than one defect, it is not in substantial compliance, cannot be amended under Section 12. We have more than one defect.
So the problems with that first lien was the reference to lots 35 and 1503. Am I correct?
That is correct. And that itself, because 1503 is very critical, it attaches itself to 60.8% of the common elements in the building. That violates lien law, real property law 33.9L, which says you cannot attach common elements without the consent of the owner. So you had a lien that was literally, but what is important here is that they filed two liens. They filed a first lien and a second lien. Both liens put a blanket lien on the entire building. What happened?
There are a lot of facts in this case, and I know you argued a recent appeal just recently on a related case, but my question is, during the discovery process, and it doesn't seem like this case has gotten too far in a long time, after all these years, weren't they asking you for an indication of which lots were which and trying to get the whole thing, and they were having a hard time getting an answer from you so they can figure out which lots? So they may have been a little bit over-inclusive, so they would be sure to include everything correctly?
I'm glad you raised that question. That's an entire accurate description, Judge. The subordination agreement on page 2468 was filed 2 years before they filed their lien. 2 years. It was on Acris, Judge. I went on Acris, you can go on Acris, and you can see it. 2 years before this lien was filed, the particular lot and block number was there. So why didn't they do that? And this court has said the failure to exercise due diligence in determining which block and lot number to lien does not excuse the failure to do it properly. That's what they did. They had an opportunity. It's right there, Judge. Record page 2468. You will see it there 2 years before. It is inexplicable that he should come and say, I didn't know which lot.
Counsel, so did you ever tell them after they requested, like my colleague asked?
Oh, of course, we communicated with them.
In February of 2023, you finally told them?
No, Judge, but here's the issue, Judge. The determination of when, there was no attempt here to conflate or conceal anything. It was a matter of public record, Judge. It was there.
Counsel, let's agree with you that is a matter of public record. Did they request it from you, and did you take your time responding?
I don't know if I took my time, Judge, but we gave them a complete representation of the situation. What should be borne in mind, Judge, that lien is determined at the time it's filed under the lien law. They had the obligation to go and search Acris. This is not a secret. Acris is a matter of public record.
I understand. You're over your time. You'll have some time on rebuttal.
I'm sorry, Judge?
You'll have some time on rebuttal.
Thank you so much
Thank
for
you.
your indulgence.
Good afternoon, Your Honors. John Ciani, Getz Fitzpatrick, Getz Platzer, here on behalf of Vanguard, the respondent.
What about the filing that counsel has just indicated, that you didn't file it on time?
11B was never the subject of the summary judgment motion. It's not a subject of any of these pending proceedings. It's not a matter that's before your court. And the order was filed. The order was filed to amend the lien, and that's been satisfied. There isn't any requirement under 11B that relates to when a lien has been amended by order that you have to follow this separate supplemental service. So it's just not a requirement under the statute. And again, it's not before this court in any shape, way, or form. In terms of what the record is about what's in a subordination agreement, all that document does, when you'll look in the record, is identify individual lots. It never says where the work is being done by PIPs. All the cases that are cited in our brief, and they don't cite anything to the contrary, when you have a situation where you refer to the predecessor lot, and you also refer to other lots that are still owned by the same owner, same sponsor, so they continue to own those lots, and to this day they own 1501, 1502, 1503. The cases consistently say in every single instance that lien is valid. There's not jurisdiction, two mistakes under 9.9 Part 7 of the lien law. There's one issue. You're supposed to define the property correctly, and so if you overstate the lots, that's one issue. It's not two issues. Lien law section 23 applies, and all the courts are consistently held. There's no harm. Everyone knows what's going on, as your presiding judge noted. It's very clear to the owner that they're being faced with a lien. Because he didn't refer to anything other points that were raised in the appeal, I don't need to bother addressing any other points.
Thank you.
Brief reply, Judge. Section 11B specifically reference Section 12A, not limits 12A. That's where the amendment occurs. Whether it's by freely or by court order, it is required that you comply with 11B. Separately, Judge, it is not true that the subscription agreement did not identify the lot and block number subject where the work is going to be performed. What it did was it identified the premises leased by PIPs, and it is acknowledged by him and by Vanguard that the work was to be performed in the space that was leased. So the suggestion somehow that that agreement, which was on Acris, doesn't tell them where the work is going to be performed is complete nonsense. What he did here is that he liened the entire building.
But you knew, I mean, you Vanguard No, you 400 times, I'm sorry. You're 400 times, right? That's your client?
That's me, Judge.
So you knew that the work that Vanguard was doing was for PIPs who leased, you know what they leased because they leased it from you.
Well, Judge, if you...
And you approved all their work.
Actually, that's not true, Judge. And I'll tell you why that's not true, and I'm glad you raised that point. Consent under Section 3, Judge, requires that we approve the work that's being done for us. This was an empty space. It was a cold shell.
They built it out.
They built it out for their purposes. If this court determines that that constitutes consent, every new landlord, every new building in the city will be subject to a lien, because you cannot perform work in a new construction in an empty shell without some cooperation, if you would, from the landlord. To turn that now into a consent would destroy the real estate market in New York City. This case, if you follow this logic, Judge, and this conclusion, will destroy every landlord will be unfair, because this is an extraordinary overreach. Thank you.
Thank you. Thank you both. People versus Zeliang Pan.
Good afternoon, Your Honors, and may it please the Court. Jane Merrill for Appellant Zeliang Pan. A conviction cannot be based on criminal acts that were alleged at trial for the first time. Such an approach necessarily amends the indictment by altering the theory of the prosecution from that presented to the grand jury. It is not only contrary to CPL 200.70, it completely upends the purpose of an amendment, of an indictment.
Excuse me, it's my understanding that we're talking about just getting more accurate time frame for the abuse, which has not really changed. The abuse was constant over a certain period of time. The child victim may not have been accurate, and there's information in the record that suggests that child victims may not be accurate about periods of time when certain abuse takes place because of the trauma. So merely to give an expanded time period for it doesn't change the heart of the charges that your client was facing. The same charges, just having added periods of time for it. How is that so prejudicial and problematic for reversible error?
Your Honor, I wouldn't be up here if this were merely about shifting the time frame, but that's not what happened here. By expanding the time frame here, at least 2, if not more, substantive acts were added to the indictment. So
was this a course of conduct, or was this each individual, indictment of each individual act of abuse?
Yes, Your Honor, this was charged as predatory sexual assault of a child on the theory of course of conduct, so it was not charged as every individual act, but the theory here, and the theory I would submit in any case like this, is comprised of those specific and discrete acts. And
the theory doesn't really change. I mean, doesn't CPL 200.70 subsection 1 allow amendments in this kind of a situation where there may be some errors of the exact time, but that the theory of the prosecution is, as reflected before the grand jury, and that what you presented before the grand jury still is the same?
So, Your Honor, the theory here changed because the amendment did not just change the time, it added substantive acts. It added different substantive criminal acts that were not allowed.
Substantive acts, that the indictment included a course of conduct, right? So those acts could be determined to have been included within the indictment. All it did was that it gave the appropriate timeline. And in a case where you have a child victim and you have an expert testifying that this is not unusual for child victims, I don't understand what you want us to do.
Your Honor, this would be a very different case if all that had happened was that at the stage of indictment...
Is it your argument, I'm sorry, I don't mean to interrupt, but I just want to shortcut this a little bit. Is it your argument that if the people say from day A to day B, they're locked in and that's it?
No, Your Honor, not at all. The issue here was that it wasn't just, we moved from A to B to C to D. That's not what happened. This isn't a question of the complainant's memory changing. This is a case.
So is your argument then that because the date was extended by, I think, 2 months, right? Because the date was extended, that now they could introduce evidence of 2 other acts that they otherwise could not have?
In part, Your Honor, yes. So the indictment was amended to include 1 full year on the back end and about 3 months, as Your Honor is correct, on the other end. And that did permit the complainant to testify to more and different criminal acts than were presented to the grand jury. There are 2 that we can pin to those timeframes. One is that at around 3rd grade, 2016, the complainant alleged that my client lured him into his room and vaginally raped him. On the other end, the complainant alleged that he was forced to perform oral sex on my client. Those are entirely different acts than were presented to the grand jury. Yes, they are the same kind of conduct, but the same kind of conduct is not a theory. That is precisely what the 4th Department held in
Course of conduct is a theory, right? And they're within that.
Course of conduct, Your Honor, respectfully, is the name of a statute. It's an element. A theory is how a crime is committed, the substantive acts that make that. I would submit, actually, that it's the central action details that the prosecution's own expert are the core of what makes an allegation that puts meats on the bones of an allegation. That's the who, that's consistent. The where, that's inconsistent. And the what, the kind of sexual act. The complainant never mentioned a word about anal rape at the stage of indictment. That was for the first time brought to light at trial, and that's a problem. That means that this court can have absolutely no confidence that my client was convicted of the same acts for which he was indicted. The same statute with the same elements, sure, but that's not the standard. The standard is the theory, which is comprised of specific acts.
So your position that the people could only introduce evidence at trial of acts that were squarely presented to the grand jury?
Yes, Your Honor. And that serves the function of the anti-usurpation doctrine and the notice function, and really does give us that assurance that there is some match between these things to fulfill the function of a grand jury and to fill the function of an indictment.
What your argument preserved? Did you raise it below?
I'm sorry, I didn't hear you.
Was this preserved? My understanding is you concede that it wasn't preserved.
No, Your Honor. This argument is preserved, particularly as to the written amendment, because that was discussed both at the stage of motions in limine, when the prosecution initially indicated that they would seek this amendment, and after the presentation of the evidence, when they did seek this amendment, the written amendment was objected to on the grounds that it added new substantive acts beyond merely changing the time frame. I would concede that there are other acts that were not described to the grand jury that were alleged at trial, and that those constitute an unpreserved constructive amendment, but these issues are really going hand in hand. They're so closely intertwined that to the unpreserved constructive amendment, I would ask that this court reach that in the interest of justice. Thank you.
Thank you.
Well, hello again, Your Honors, and may it please the court, Alex King for the people. The court's grant of a motion to amend the time frame alleged in the indictment was a provident exercise of discretion. Amendments as to the time frame are very common in child
So
sexual...
how do you respond to your adversary's position that it wasn't only an amendment as a time frame, but in fact it permitted you to include substantive acts that were not before the grand jury?
So this is defendant's separate claim about constructive amendment, which of course is unpreserved, as defendant admits. And not only is his claim unpreserved, it is meritless. His entire argument is founded on a comparison between the evidence presented to the grand jury and the evidence presented at trial. But we know that as a general rule, if there is no variance between the trial evidence and the language of the indictment, any discrepancy between the trial evidence and the grand jury evidence is irrelevant. And in this case, the language of the indictment matched trial evidence exactly. It bears note further that even if the top count, the persistent sexual assault count of this indictment had limited the type of sexual conduct at issue, evidence of other types of sexual conduct
would have been admissible and properly admitted at trial as evidence of the second count in the indictment, child endangerment. I'll add further, defendant's complaint about adding a new actus reus to the indictment is inapt because, as this panel noted, he was charged with 2 continuing crimes. The relevant actus reus in this case was his entire course of conduct in victimizing the child here, and the allegation that he engaged in such a course of conduct never changed. If there are no further questions, we ask that you affirm.
Counsel, may I ask you a question? The court, as I believe it was required to, did offer the defendant an opportunity of an adjournment to do some further preparation in order to deal with the amendment, and that was declined by the defendant. So, I mean, how does that play in? I mean, you could have taken advantage of that situation, not you, but the attorney trying it. So can you address that?
Yes, happily, Your Honor. So there are a couple of issues intertwined here. First, at the point that defense counsel declined an adjournment, that was at the motions in limine stage. And at that point, the prosecution had only asked for that 3-month differential between March and June, not the entire year. So it does look very different on the back end once the evidence is all before the court, and we have all of these much bigger differences, including an additional year. Secondly, an adjournment really wouldn't cure the problem here. The problem here is of a constitutional valence, not of twiddling at the edges that 200.70 contemplates. This isn't just as to time or to those sort of instrumentality that 200.70 contemplates. So the fact that counsel declined an adjournment really doesn't reflect on prejudice here, because prejudice is not required to be shown because this did go to the theory, which is distinct from the other sorts of amendments that 200.70 contemplates. I did want to clarify a few other points. Respondent essentially approaches and advances an exception to the rule that a conviction cannot be based on criminal acts that were alleged for the first time at trial, based on the fact of this being a continuing crime. This is a continuing crime, but no court has ever adopted such an exception. Continuing crimes are meant to solve the problem of the duplicity of an indictment. That's not what we have here. These are entirely different theories, and the theory has to remain the same, and it didn't. Therefore, I would ask that you reverse. Thank you.
Thank you. Thank you both.